My name is Wesley Shackelford. I'm with the Texas Indigent Defense Commission, and I want to welcome you to this presentation on new attorney reporting requirements. We've been doing presentations in person around the state, but wanted to make this information available to a wider audience. This is the mission of the Texas Indigent Defense Commission. We're an agency that provides grants, technical support, and has authority to set policies and standards to improve the state's indigent defense system. And of course, you're welcome to view more information on the Commission on our website. So today we're going to cover new requirements from House Bill 1318. It was passed by the 83rd Legislature in 2013, although the requirements had a delayed effective date and are coming into effect this year. The first one I'm going to cover is new attorney reporting requirements. That's the main focus of this presentation. I'll also be talking about the county reporting requirements related to attorney cases. And finally, I'll be touching on the weighted caseload study that was also mandated by the legislation. And by way of background, the legislation was not a proposal from the Commission, but through our attendance at hearings, I learned that the main focus of the legislation was attorney caseloads and concern among some legislators at very high attorney caseloads and the effect that they may have on the quality of representation provided to indigent defendants. So next we're going to talk about the new attorney reporting requirements, and this is the provision that was added to the Code of Criminal Procedure, Article 26.04, and it requires that not later than the October 15th of each year, on a form and manner prescribed by the Commission, each attorney must submit for the preceding fiscal year a report that describes the percentage of the attorney's practice time dedicated to work based on appointments under the Code, as well as under Title III of the Family Code. So that is referencing appointments in criminal cases in state courts. That's the Texas Code of Criminal Procedure. And then Title III of the Family Code is the Juvenile Justice Code, so delinquency cases. So the new reporting requirements for attorneys covers the prior 12 months. So that's going to be October 1st of last year through September 30th of this year, an assessment of your practice time during that time period. There's also an optional attorney worksheet, which I'll cover in a few minutes, that is provided to assist you in estimating your practice time. The report applies to all appointments in indigent defense cases, and that includes public defenders, contract attorneys, as well as all assigned counsel, private attorneys who handle indigent cases on an appointed basis. The penalties for failing to submit the report have not been provided in the legislation, but may be set by the judges. And they may include removal from the appointment list until the report is completed, as many do presently for late CLE reports. So to complete this report, the Commission has provided both an online form as well as a paper form. And each jurisdiction sets which method they're going to use to require the attorneys to report. There are some advantages to the online form, and we've been encouraging jurisdictions to adopt that method. First, for attorneys, it means that you will be able to report to all counties at the same time, rather than a paper form to each county in which you accept indigent appointed work. The advantage for the counties is that they will not then need to forward those reports to the Commission. Since it was provided online, it would come directly to us and be available for their viewing as well. The attorney reporting portal itself, the address there is shown, and the site is now available for you to complete the report. So next we're going to take a look at what the attorney reporting portal looks like. To access the system, you will need to input your bar card number. We have a database that includes every currently licensed attorney in the state that's refreshed every month, so it should be current and you should find yourself there. You'll enter your number, hit enter, and you will then see your name populated. Confirm that, and you will be taken to a screen that looks much as this slide. On the left side, you'll see a drop-down menu with county names in it, all 254 counties available for you to select. In my example, I selected Travis County first, and then went over to the two columns and entered the percentage of practice time I dedicated to appointed criminal defense cases in Travis County, 23% in that case. In juvenile delinquency cases, I handled 5%. Because I also handled appointed cases out of Williamson County, I went to the second row and selected Williamson County from the drop-down menu. and then entered my practice time in that county, 12 and 5% respectively. At the end of that, concluded my report, it shows that there are 45% of my practice time dedicated to appointed criminal and juvenile work in these two counties. You'll notice that it won't add up to 100% unless you devote your entire practice to indigent appointed criminal and juvenile cases. That may be a scenario for public defenders among our attorneys, but for most private attorneys, that won't be the case. The last thing that the report asks you to fill out is how you calculated that practice time percentage. Was it through time records, case counting, some combination of those two methods, or some other method? And we'd ask you to indicate in the text box what other method you used. At the end of that, you simply hit the Save button at the bottom of the screen, and you've completed the attorney practice time report for this year. Next, we're going to look at the optional attorney practice time worksheet that the Commission promulgated to assist you in completing the required form. It's not mandatory, but is intended to be a tool that was developed with partners at the Texas Criminal Defense Lawyers Association, and it assists in helping you allocate 100% of your practice time by listing the various case types that you may have, as well as the definition of practice time. The link to the worksheet is provided on the attorney reporting portal. This is what the optional attorney practice time worksheet looks like. It's an Excel spreadsheet that will open on your desktop from the link provided on the attorney reporting portal. It has instructions on how to complete it, and you'll want to pay particular attention to the green fields, which is where you'll input the percentage figures for the various practice types that you have. First, we'll look at the section dealing with your non-indigent defense practice time, and that's that first row of fields. There's listed for you to account for any federal criminal practice that you may have, retained criminal practice, practice in other civil areas or lobbying, other types of legal work that you may have as part of your practice, and finally, appointed work other than indigent criminal or juvenile defense, such as CPS appointments. And here's that same field with data entered in. So in this example, 10%, 15%, and 10% of practice time allocated in the first three categories of case types. Now let's look at the section of the worksheet dealing with the percent of your practice devoted to indigent defense cases. So the first thing you're going to do is enter the county name for each county in which you handled indigent defense cases last year. You'll start by clicking in the field underneath the county name, and an arrow will appear with a drop-down menu with all 254 counties listed. Simply select the counties in which you've completed work. Here's an example of someone who's entered work in 3 different counties. They've listed the percent of their practice time in criminal cases in the first column, and in the second column, the percent of their practice time devoted to juvenile appointed cases in each of those counties. You'll notice that summing these along with the other case types that we looked at earlier, the grand total now equals 100% of this attorney's practice time. Once you've allocated all of your practice time and the sum has come to 100%, you'll want to take the figures in the green blocks on this screen and report them in the attorney reporting portal that we talked about earlier. These are your percent of practice times for each county in the state. Next, we're going to talk about the new county reporting requirements that begin November 1st of this year. This is the section from the government code that mandates that new report, and it says that not later than November 1st of each year, in the form and manner prescribed by the Indigent Defense Commission, each county shall prepare and provide information that describes for the preceding fiscal year the number of appointments under the Code of Criminal Procedure and Title III of the Family Code made to each attorney accepting appointments in that county, as well as information provided by the attorneys to the county under Article 2604. If your county uses the online attorney portal that we've just discussed, the county won't have to include that step because the information will have come directly to the commission. But otherwise, this is the basis for the new county reporting we'll discuss next. So in figuring out how to implement these new county reporting requirements, the Commission convened several work groups of stakeholders consisting of county officials, criminal defense attorneys, auditors, judges, and advocacy organizations to consider how to do it. And the consensus was to build off of the existing infrastructure that's been in place for the last 12 years. And that consists of an annual expenditure report, also contained in the same section of the government code, that requires the county auditor in each county to report aggregate figures of the number of cases paid by case type. And you can see the various case types: juvenile, capital murder, adult felony, adult misdemeanor, etc. Cases paid is a term that we use because we're counting the case at the point in time the auditor pays an attorney for the work on that case. So rather than counting it at the time of appointment, we count it at the end of the case. And these reports are already required to be done by court. So you can see in aggregate the number of cases paid in each court by each case type. The auditors across the state indicated that we should continue to follow this model since they already collect the information by attorney. Of course, with each attorney fee voucher that's submitted and processed by the auditor, they already capture the attorney as well as the case type and the court and the amount paid to the attorney. So the decision was reached to build off that report and require the reporting to be by attorney, including the case type and court that each of the cases were disposed of, and then the total amount paid to each attorney. Once this reporting comes in, we'll be able to combine it with the attorney practice time reports that you're completing and get an overview of the average amount of time spent on representing each indigent client. Looking at the case data reported by the counties, we'll also be able to get a sense of how many cases attorneys are handling overall, the types of cases, as well as the distribution of the cases among attorneys and how closely that distribution follows the wheel or rotation system. The last thing I'm going to cover today is the attorney weighted caseload study. HB 1318 included this provision mandating the study, and it says that not later than January 1st, 2015, the Indigent Defense Commission shall conduct and publish a study for the purpose of determining guidelines for establishing a maximum allowable caseload for a criminal defense attorney that allows the attorney to give each indigent defendant the time and effort necessary to ensure effective representation. This is the first caseload study of its kind in Texas, and it's the first mandated by legislation in any state. The Commission contracted with the Public Policy Research Institute at Texas A&M University to help conduct the study, and it partnered as well with Texas Criminal Defense Lawyers Association, State Bar, public defenders, criminal defense attorneys, as well as a group of national experts who've been involved in similar caseload studies in other jurisdictions. We've also developed a website that provides information about the study and tracks its progress, and that site is provided on the screen. The weighted caseload study consists of three main parts. We began with a time study where attorneys were recruited to track the time they spent on each case by case type. There were 140 attorneys that participated over a 12-week period. That was then followed by a sufficiency of time survey where the results of the time study were sent out to a broad cross-section of criminal defense lawyers in the state who were asked to indicate whether that time was adequate, and if not, how much more time should be allocated or less to each of the tasks involved. The last phase is an expert review of findings, convening a panel of highly respected criminal defense lawyers from across the state to complete an independent assessment of the amount of time that should be devoted to different types of activities on cases. Ultimately, this is going to result in the recommended caseload standards and a final report, which will be issued by the end of this year. Well, that brings us to the end of the presentation. I want to thank you for viewing it. Here's my contact information, and I'd welcome any questions or concerns that you may have. Feel free to email or call. Thanks again.